Many people have asked me the question whether you can be convicted of being drunk in charge of a vehicle whilst asleep in that vehicle in a car park. Now, whilst every case turns on its own facts, this is one such example where that was not held to be the case, although it did have to go to the Court of Appeal first, so don't count your chickens. So this was a case that was ultimately appealed by way of case stated. That means the lower court states the case, as in it outlines the facts of the case and the questions for the appeal court to answer. The original court was the Magistrates' Court. Now, the Court of Appeal ultimately decided that the justices had been wrong to convict this individual of being drunk in charge of a motor vehicle in a public place whilst unfit through drink. And in this case, the individual had been sleeping in a van in a car park, but the appeal court found that there was insufficient findings of fact to support the justice's conclusion that this car park was a public place. Allow me to explain. So this individual had been working as security at a pub and essentially living in his van. On the day in question, however, he wasn't working, but he had been drinking in the pub and his van was parked in a nearby car park. This car park had 2 entrances and exits, but without barriers, and it had various different signs within it, some of which stating that the car park was private for customers and only for specific businesses. In addition, certain parking spaces individually were marked as private, and so the event in question was that this individual left the pub and fell asleep in his van, after which one of the members of staff called the police. The police duly came out and charged this individual under the Road Traffic Act for being drunk in charge of his motor vehicle in a public place. He pleaded not guilty to the charge, maintaining that this car park was not a public place, and accordingly made a submission of no case to answer, which would have given the justices the opportunity to stop and throw out the case, essentially at what we call the halfway point, that is, at the close of the prosecution case. However, the justices went on to convict him and found that the car park was a public place with varying restrictions and that he had been parked as a member of the public because he hadn't been working. However, this is where it gets really interesting because the appeal court obviously allowed the appeal and overturned the conviction. The appeal court emphasised that there was no statutory definition of a public place within the Act, whereas road was defined as any highway or other road to which the public has access. So for that purpose, road was to be considered as any other place to which the public had access, and the court looked at other previous cases. The relevant legal principle here that there was no evidence that the public actually used these premises, and the court held that it was insufficient that they could have access to it if they wished to, but otherwise these premises were private because they were intended for business purposes only, with obvious exceptions being those that provided public services, such as stations and hospitals. And so in essence, the public's use of the place had to be one that was lawful, in that they had either express or implied permission to access it. And accordingly, when looking at this case, the appeal court said that the car park appeared to have several different areas, at least some of which were unquestionably private, and further that there'd been no definitive finding of fact as to where this individual had parked, and that he could only be convicted if he had parked in a public place. And naturally that depended on precisely where within this car park he'd been parked. And further, since there'd been no evidence that members of the public used this car park, save for business purposes, there should have been no case to answer when the case was first heard in the Magistrates' Court. So on this very specific set of facts, the appeal was allowed and the conviction overturned. So as I said, every case will turn on its own facts, and if the public does have general access to this car park, and it isn't, let's say, definitively out of hours, definitively private, and definitively not for public access at the time the person is found there, then it may well be considered to be a public place. And so if you are found to be asleep in the back of a vehicle and there is a real prospect of you driving the vehicle and you cannot prove otherwise, then you may well be drunk in charge of a vehicle in a public place if the car park is deemed to be a public place. So I for one would humbly suggest that a court is not the appropriate place for you to test out theories with a particular car park as to whether you'll be found drunk in charge. But nonetheless, I hope you found this interesting. Please remember to like the video, subscribe, and I'll see you next time.